Morning.
Good morning. Are you Kristen Bell?
Yes, ma'am.
And Ms. Bell, this is your initial appearance in cause number 25 DCCR 1812. You are charged with injury to a child, elderly, or disabled individual. It's a state jail felony from October 6th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am. Whenever I spoke to the judge, I told him I would do a court upon it.
Right off the bat, notice how the judge is clearly setting expectations for Miss Bell. Even though she made bond, she's not off the hook. Hiring a lawyer is still on her. This is a perfect example of how initial appearances aren't just formalities. They set the tone for the entire case.
Right. So when you're in custody, we automatically would give you a court-appointed lawyer. Since you've made bond, I expect you to try to hire a lawyer. So what I'm going to do is reset your case about 30 days or so to give you some time to see if you can get someone hired. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Okay.
If you're unable to hire someone for the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options.
Okay.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail.
Okay, here's the tension. If she doesn't talk to at least 3 lawyers, her bond could be raised and she could end up back in jail. That's a real follow instructions or face consequences moment. What would you do if you were in her shoes?
Okay. Step in front of the clerk right here. She's going to give you your reset notice. Yes, ma'am. Raquel and Gilbo. Good morning. You're Raquel and Gilbo?
Yes, ma'am.
And Ms. Gilbo, did you get someone hired?
It's not, no, ma'am. I can't afford any lawyers. I have tried. I called like more than 3, and they all told me their prices, and I just can't afford them.
Who'd you
But I
talk
have
to?
talked.
You can just tell me the name.
I talked to James, I think wife, Kimber, and Brian Gertz.
Okay. How old are you? You're not in school?
No, ma'am.
Okay. Are you working?
No, ma'am.
Aren't you working?
I actually have a job. I'm back at home in Houston, but I had to come out here so I can figure this out.
Okay. So thank you for doing what I asked you to do. I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer.
Yes, ma'am.
You need to fill it out.
This is the court's process for determining eligibility for a court-appointed attorney. It's interesting because the judge emphasizes honesty, filling out paperwork accurately under oath. Even small mistakes here could slow things down or affect representation.
But accurately and completely. Don't leave zeros on everything. Just write whatever bills you have, whatever any income you might have, and then I'll take a look at it. You're going to swear under oath that it's all true.
Okay.
Step in front of the clerk. She'll give you that paperwork. Good morning.
Good morning.
Are you Alyssa Bush?
Yes, ma'am.
And Ms. Bush, this is your initial appearance in cause number 25 DCCR 1754. You're charged with the state jail felony offense of credit or debit card abuse, and that's from September 6th of 2025.
Yes, ma'am.
And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
We couldn't afford it. Our bill's sponsoring, so that today would be the day to fill the paperwork for an appointment.
How old are you, Ms. Bush?
I'm 17.
17. Are you still in school?
Yes, ma'am.
Where do you go to school?
Either in high school.
Okay. So I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely. You're going to swear under oath that it's all true and correct, and then I'll take a look at it.
Yes, ma'am.
Step in front of the clerk, and she'll give you those instructions. George Del Fiero. Good morning.
Good
Is
morning.
it George or Jorge?
Oh, okay.
Okay. And did you get someone hired?
Yes, I got right down, but I stole like 120.
Okay. You brought a receipt? Good. So when will you be able to get him? You think the next couple weeks, 3 weeks? Okay. So we're just going to do one more reset.
Yes,
to
ma'am.
give you some time to get him paid off. Okay.
Okay.
Make sure you bring that reset notice to his office, and they'll tell
Yes,
you what to do.
Thank
You'll
you.
step in front of the clerk, please. That was missing a TRN, but it didn't make the big loud sound, which makes me wonder if my sound is. Good morning. Are you Patrick Brooks?
Yes, ma'am.
And Mr. Brooks, this is your initial appearance in cause number 25, DCCR 1652. You're charged with the state jail felony offense of fraudulent use or possession of identifying information, and that's from October 8th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, actually, I was never booked in through Jefferson County or anything like that. I actually got picked up January 1st of this year, stating that I had these warrants. And then I had to bond out. I had to spend $2,000 to get out. After speaking to investigator Reggie Boykin and the sheriff's office right here, I talked to Miss Brooke. They found out that it was another guy named Scott Anthony Doss using my name. I had to go do an identity report and stuff like that. Like, here's some dates where it's like I heard he got picked up October 9th as well for something. Then also in Orange County.
So hang on just a second. That's all information.
Whoa. Patrick Brooks has a classic identity theft story. He's explaining how someone else used his name, and the court has to carefully untangle this mess. Cases like these highlight why initial appearances aren't just a formality. They're where facts get straightened before any legal strategy can happen.
Information that probably the district attorney needs, not me. So, is Mr. Coleman going to be here?
Yeah.
Okay. When he have a seat. When Mr. Coleman gets here, would you have him take a look at this? I'm going to have Mr. Brooks have a seat. Sounds like there's some information.
I think he needs to go up and tell the front desk.
I did meet you before.
Have to be considered.
He's already done some of that. Sounds like, and I mean, yeah. Yeah, when Mr. Coleman gets here, would you just have him just have a seat? When when the assistant district attorney that's assigned to your case gets here, here in the courtroom. Good morning. You're Miracle Oville?
Yes,
And Ms. Oville, this is your initial appearance in cause number 25, DCCR 1779. You're charged with the third-degree felony offense of tampering or fabricating with physical evidence, and that's from August 31st of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I have not.
Okay, so what I'm going to do, Ms. Oville, is reset your case for about 30 days or so to give you some time to try to hire a lawyer.
Can we do maybe 60 to 90 days?
I do 30 on all of them. And so here's the thing. If you can't hire someone in the next 30 days, I want you to at least try. If you make a down payment to someone, bring me a receipt. If you're unable to hire someone in 30 days, then I'm just going to order you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me the names of the lawyers you've talked to when you come back, and then we'll discuss your options if you need more time and things like that. But we're going to do every 30 days until we get it figured out, okay? So if you get someone hired, bring the reset notice that you get today to that lawyer, and they'll tell you what to do. Again, if you're not able to hire someone, make sure you speak to at least 3. Bring me those names. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order I just gave you, and you would have to go back to jail. Do you understand?
Yes, ma'am. Can I just say that I was under the impression that when I spoke to my bail bonds that was a court-appointed attorney.
So when you're in custody, you automatically would give you a court-appointed attorney. But once you make a bond, then I expect you to at least try to hire your own.
Okay.
So follow those rules, try to hire someone now that you've made bond, and just do everything I asked you to do. Again, if you get somebody hired, bring the reset notice to them. If you can't, visit with at least 3 and bring me those names. Okay?
One last question. Does the attorney have to be out of Beaumont?
No. They can be wherever as long as they practice here.
Okay.
Just make sure that whoever you're talking to, if it's out of town, make sure they know that the case is in Beaumont.
Okay.
Notice the 30-day reset system the judge uses. It's not arbitrary. This keeps cases moving while giving defendants a fair shot at legal representation. But the judge also stresses accountability. No follow-through could mean bond increases or jail time. If you were hiring a lawyer under these conditions, how would you prioritize your options?
Sometimes if it's out of town, they might charge a little more because they have to come here. They may say, I don't travel to Beaumont. I'm not sure. Where are you from?
I'm coming from Richmond, Texas.
From Richmond?
Yeah.
There's definitely Houston attorneys that come here. It might be more reasonable to talk to some here, but I'll leave that up to you. You can visit with whoever you want to. Okay? Go step in front of the clerk. She'll give you a reset notice. Good morning. Are
Good
you Crystal
morning.
Latulis?
Yes, Your Honor.
And Ms. Latulis was previously in court, entered pleas of guilty in cause numbers 25 DCCR 0850 and 0851. I've received that pre-sentence report. Has everyone had an opportunity to review it?
Yes, Your Honor. Yes, Your Honor. Yes.
Any additions or corrections?
Oh, Your Honor. Not from the state.
And so, what is the status? Is Child Protective Service still involved, or have they closed out their case?
They closed it.
And where are the children?
I have 4 of them with me and 1 of them with my grandmother, Your Honor.
And that is what the plan was with CPS?
Yes, ma'am. Yes, Your Honor.
So, Kylan, the one that had to do with this offense, is with the grandmother.
Yes, Your Honor.
What is the plan with regard to that? Sorry, is it a boy or
It's a boy.
is that plan for him to stay there, or are you wanting to have him back?
Yes, ma'am. I want to have him back, Your Honor.
Gilbert? Gilbert?
Mr. Nichols,
Yes, Your
what
Honor.
are your thoughts on with regard to?
All my indications in your CPS closed the case out, and that she's done everything they'd asked her to. Looking at the facts of this case, it seems like it was a one time, and I think CPS hasn't really weighed in against against child law. So if she's doing the steps she needs to, then that's part of what's in the child best interest.
Thank you. And did you already do a parenting class?
Yes, Your Honor.
One of the recommendations is for you to complete a parenting course offered by Faith Tabernacle
I
Church.
did.
You already did.
I did, Your Honor. Yes, ma'am.
Okay. All right, then I'm going to find in each of your cases, Ms. Latulis, that you previously entered your pleas of guilty freely and voluntarily. Find sufficient evidence in each case to find you guilty. However, in cause number 25 DCCR 0850, I'm going to follow the agreement, defer all proceedings, and place you on probation for 5 years. You're ordered to pay a $500 fine in that case and follow all of the rules and conditions of probation.
Yes, ma'am.
And cause number 25 DCCR 0851, also find sufficient evidence to find you guilty. I'm going to follow the agreement in that case also and defer all proceedings, place you on probation for 5 years. You're ordered to pay the $500 fine in that case and to follow all of the rules and conditions of probation. It sounds like you're already well on your way to doing what you need to be doing. I'm not at this time going to order the no contact. It looks like you've already followed through with the parenting class and everything you needed to with CPS. Obviously, especially this child needs special care.
Yes.
And so you know that as well as anybody.
Yes, I do, Your Honor.
If you do everything that you're supposed to on this probation, then this is a great opportunity because you don't have felony convictions on your record. And if you successfully complete the probations at the end, your cases will be dismissed. You'll never be a convicted felon. The other side of that, though, is if you violate any condition of the probation, don't follow any of the rules, you can be brought back into court. You can be found guilty in each of the cases, and you can go to prison for anywhere between 2 and up to 20 years.
This is a huge moment. Completing probation successfully means no felony convictions. But slip up, and suddenly prison time of 2 to 20 years is on the line. The stakes couldn't be higher, and you can see how every step, from parenting classes to court orders, matters in these cases.
You understand?
Yes, Your Honor.
All right, I'm handing you the trial court certification that shows these were agreements that I followed, so you waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork.
Yes, Your Honor.
Good luck.
Good day.
Yes, ma'am.
Thank you, Your Honor.
Ernest Sinnett.
He was there. Well, he's here.
Let me check. Show fire. Yep. No.
That's here. Else here. True or not
That's
true?
good.
Please.
Mr. Sinnett, the best you can, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
True.
Thank you, sir. You put your hand down. And will your client waive the formal reading of the motion?
You will, Your Honor.
Mr. Sinnett, in cause number 21-37107, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation February 17th of 2025 for the offense of indecency with a child by sexual contact, and that was a 10-year deferred probation. Is that correct?
Oh, yes.
Okay. This motion alleges that you violated your probation. Count 1 alleges that you failed to successfully complete an approved sex offender treatment program with a licensed sex offender treatment provider. And is that true or not true?
Not true.
Count 2 alleges that you failed to submit to a polygraph examination or other evaluative examinations on May 17th of 2025 at the direction of probation. Is that true or not true?
Not true.
All right, so I'll have pleas of not true entered for counts 1 and 2. What we'll do is reset this for a hearing. I would assume it wouldn't take too much time, just the probation officer probably. All right, so we'll reset this for a hearing on sentencing. Obviously, if there's anything that's important for me to know, make sure you get that information to Mr. Parker, as this is an open plea, and I'll determine if those things are true, and if they are true, what, if any sentence should be imposed at that time. Okay?
Okay.
All right, we'll see you back at the next court date. If you'll step in front of the clerk over here, she needs your fingerprint.
She did from JCBI on that.